Hello, this is Antonio Gangali. I'll be discussing the United States of America versus Union Cheese Company. I believe the order is impossible. Within the order, it states that the defendants, Union Cheese Company, a corporation, and Dominic F. Gangali and M. Gangali, individuals, and all of their officers, directors, agents, representatives, employees, attorneys, heirs, assigners, successors, and any and all persons in active concert or participation with them are hereby permanently restrained and adjourned. Goes on to say, unless and until A. defendants have established and implemented adequate methods, facilities, and controls for receiving, manufacturing, preparing, packaging, distributing, and holding articles of food in the facility to ensure that articles of food are not contaminated with Listeria Mono bacteria, other pathogenic bacteria, or filth. Such methods, facilities, and controls shall specifically include, but should not be limited to, the following. And there were pages of mandates. So here again is that order. Here's further pages of requirements. Again, more requirements, and there was also a supplemental order. So this order was under civil and criminal contempt. So within some of those pages of mandates, there was the requirement thereafter for a period of 1 year and as frequently as specified by the FDA, or if Listeria Mono is found in the defendant's cheese, food processing, or storage environment after entry of the order for additional year from the date of such discovery. The independent laboratory shall contemporaneously forward the analysis worksheets, tests, records, and results for all such testing to defendants and the FDA Cincinnati office. So you'll notice that it's for a period of 1 year. And if you analyze what the FDA were doing during the multiple searches, one going on 3 weeks, they would collect the inline production, raw material samples, environmental samples, inline and raw material samples. They were testing the milk silo. They were examining raw milk test records, environmental samples, the surge tank. So where this gets interesting is there's studies by the FDA in this have established that 12% of the raw milk is contaminated with Listeria Mono. And within the footnote of the case itself, there was a published paper, and within that it says analysts of raw milk in the Midwest show that 13% of the samples contained Listeria. So we'll briefly mention here that within this one published paper, it says Listeria may be present in cheese factories where good sanitation and hygiene are practiced. It says USD and FDA surveys have reported Listeria is present in more than 10% of all raw milk in the commercial U.S. Here's where it gets interesting, though. So if we just examine, if the FDA was just testing the milk silo, and if you read the order, that it was encompassing all these other things within the whole facility. So very large facility, a lot of equipment, food contact surfaces. So if you begin calculating all the probabilities, but let's just examine the milk silo. So for Listeria Mono itself, there was 12 and 13. So let's say 12.5, and Union Cheese brought in milk 365 days out of the year. Now, there's also the requirement that says other pathogens. So how do we calculate the probability of other pathogens? So if you analyze the milking process and the probability of not having any bacteria within the milk, I believe it would be well over 99.999999% that you'll find some type of bacteria within the milk, considering the commercial milk supply and how it is produced and just the anatomy of a cow. So if we have the probability of a series of independent events just for the milk silo of event 1 of Listeria Mono, here it says the probability of A occurring 365 times is 0. The probability of not occurring, approximately 6.8 times 10 to the negative 20th. The probability of A occurring, 1. The probability of B occurring, 365. The probability of B not occurring, 0. The probability of B occurring, of B occurring, 1. So the point being is, if the FDA simply tested a silo, I believe between events A and B, which the court required, I believe there is 0 probability that there will not be bacteria or listeria found within that milk. And then if you consider collecting in line, raw milk, the surge tank before the pasteurizer, the control panel, switchboards, people's hands, like all these places that they can sample, I believe it's impossible that this order could be complied with. And let's go a little further, is because you could easily determine if there was bacteria coming in because you do testing of producers and whatnot. If you wanted to examine real quickly, if there was, is you would go to the bacterial estimates of your producers or the test records, which again the government was searching. So this is just a breakdown of day 1 for Listeria in the silo. You would have a 12.5%. Day 7, 60.7%. After 30 days, 98.2%. Go on, and then you'll see day 365. So again, I believe it's a virtual impossibility that this order is complied with. But this is where it gets even interesting. So this order is handed down on June 16th. We received the order on the 19th, which was a Monday. So when things were happening, and it was basically an immediate shutdown. We could end the production on Monday. So it was causing a lot of havoc. And so one of our major milk suppliers had called me in the morning of June 20, approximately, I believe it was June 22nd. And I had conversations with him. And so the milk co-op out of New York, the President Milk, apparently had called the Food and Drug Administration trying to attempt to find resolution to these matters. During those conversations, there's an affidavit here from him. It says, during one of the conversations with Charles Sedgwick, which I believe he was the compliance officer of the Cincinnati District Office, he stated that it was going to be virtually impossible for Mr. Gangali to resume his Swiss cheese manufacturing operations. So I believe his statement is consistent with the probability of this being virtually impossible. And when we say virtually impossible, is it probably 10 to the 1,000th power, some astronomically large probability that this could be complied with. So I believe when he's saying virtually impossible, I believe this order is damn near impossible. Why this is important is I had a conversation after this call. He had called me later that evening, informing me of these conversations. So what's interesting is that the judgment comes down on June 23rd. So it appears that the Food and Drug Administration, before the judgment was entered, knew that this order was basically impossible. And it appears that the government knew. But ultimately, we would, here it says the Ohio Cheese Manufacturing District told the government he would go out of business rather comply with the court order to rid his operations of dangerous bacteria. So ultimately, we couldn't come to a resolution that we thought we could possibly, and you were facing criminal and civil contempt and unlimited mandates and the amount of inspectors and whatnot within the facility, and had to do whatever was required that they asserted. So basically, I believe it was a death sentence for the corporation. So we never really understood how the court came to its determinations, particularly that there was federal law that cheese can be made from unpasteurized milk. So we knew there was high probability of milk having bacteria. You run samples on the producers, you run it on your silos, so it's basically common knowledge that there's bacteria. So if federal law allowed for unpasteurized milk, is how did the FDA mandate zero tolerance throughout the facility? So the order did not seem to conform with federal law of allowing you to use unpasteurized milk. And also within the standards of identity of natural Swiss cheese, it further provided that milk could be raw, and you allow the aging process of cheese of 60 days to age it to kill off pathogens. And so if you understand the manufacturing process and where 60 days would be within the manufacturing, it's toward the end of production. So it really didn't make sense of why the whole facility would be subjected to a zero tolerance and other pathogens and all these other mandates, and federal law provided it to be used as raw. So we believe that it conflicted with well-established federal law. We just couldn't make sense of this order. So what's interesting is Union will ultimately sell assets to a successor corporation. Within that supplemental order that was issued, you'll see that it states the cheese manufacturer expressed their desire to sell the uncut cheese presently on hand without first complying with the terms of the order respecting the resumption of operations. It is so ordered and adjudicated decree. And also it says here that all the provisions of the court order of the June 16, 1995 shall remain in full force and effect except where expressly modified by this supplemental order. So ordered. So successor corporation was going to be subjected to this federal court order. And so it's hard to understand how it was complied with. It appears, if you look at the docket, that it was never modified from the supplemental order. If you look at the probability, it just does not seem logical that this order could have been complied with. Further, the successor corporation was taking in milk from the same truck that we had, some of the same producers were going into the facility, same truck, same driver. So I ran bacteria tests on those producers, and I don't see it possible that there would be no bacteria within that milk. That I'll examine the declarations within the case, and it appears that all three declarations submitted in this case appear to have material misrepresentations in them. And here are some of the issues that I'll get into with those declarations. So one of the main issues here is it appears that the named individuals were misrepresented. So I have a list of individuals here that I believe can attest, or they can be asked if they have ever witnessed my father in the last 5 years of within the facility during operations, is how many of them witnessed them in there. And why that's critical is because there would be issues of that he would have no direct knowledge of facts of the particular subject matter being litigated. Further, you would ask is, so within this case, they asserted that they named alleged second in command when my father's absent. So disturbingly, they had named my sister, who was a secretary. So it wasn't within her duties, and she would not have knowledge of the subject matter being particularly litigated. So again, I believe there's about 100 individuals that can attest, or if asked to examine the declarations of the named individuals to see if they're true and correct. So I believe there's issues of due process within this case regarding, also within the declarations of the expert witness. It appears that he testified that we were using raw milk, and testified to issues of levels that it could possibly be within the milk. So what's disturbing about that is Union had a high temperature short time, and during the June 22nd there was a television report. So if you examine that interview, you'll notice that they pan through the facility, and one of the photos, or you would see that there's a high temperature short time. So if you examine what that device was set at in the hold times and its design, and this was broadcasted through the Northeast Ohio. That's the territory of the Northern District Court. So the public would see that there's a high temperature short time. So if you examine the expert witness's testimony, I believe it conflicts with certain facts, that there would be legal issues with his testimony. Now, again, this goes back to the named individuals. If you examine the docketing statement, you'll notice on docket 11 here, it had a motion to drop party, and within the memorandum, there's an affidavit by my father, Dominic F. Gangali. Within that, it states that Annette is a secretary and office manager. She's a salaried employee and is not a plant manager. Further within the docket number 13, you'll see, addition, the defendants have filed a motion to dismiss Annette M. Gangali from the action of having been improperly named as a party. So multiple times you're seeing they're telling the court, they're telling the Justice Department, the FDA, that you have the bond parties named here. You'll further see within docket 3, the memorandum, there's an affidavit, again, by my father, Dominic F. Gangali. It says, I'm president and chief executive officer of Union Cheese Company. I purchased Union Cheese Company in 1977, came directly involved in every facet of the company and cheese making until perhaps 1990. At the time, for personal reasons, I have elected to take a less active role in the day-to-day operations. So if you ask those witnesses within the witness list of how many times did you witness Mr. Gangali within the operations in the last 5 years, I believe none of them can attest that he was during operations. And again, so that would, I believe, definitely raise issues that he would lack direct personal knowledge of facts to testify to certain subject matter within this case, and that there's issues with the named individuals, and there would be issues of violating due process of Rule 65. But here's where it gets extremely concerning. And they have filed a declaration of Philip, the lead investigator, in response to the motion to dismiss my sister. So if you go through his declaration, you'll see that he puts dates and things and alleged observations. You'll further see, you do not see any date or when this was executed. So we don't know. Now, what's disturbing here is, there was submission of exhibits within this declaration. However, it seems that they did not submit FDA form 484 that was on October 28th, nor the one on November 7th, and November 7th. So within those official filing documents that were prepared by the FDA is here, you'll notice that she's a secretary. So again, when you examine the affidavit that he put, or the declaration that he puts before the court, the dates that he's referring to, you'll see that the paperwork, they're referencing that she's a secretary at the time. So where this gets disturbing, so it's an undated declaration. Now, this declaration, he appears to put information that's 8 months old. During the case management of docket number 14, the court had asserted that the FDA could visit the defendant's facility and reassess current affairs. Also, it said defendants will make proprietors and managers available for depositions. Now, so why is this important? So it appears that this was filed after they had gone to the facility. So why is there an 8-month-old declaration in response to this? Why isn't there present information that he puts before the court? Moreover, why did they omit the information that she was a secretary? Further is, so they had the opportunity to reassess while they were at the facilities from May 16th, 17th, and 18th. And the Justice Department has the ability to depose proprietors. So why is this declaration, is it valid, and is there materially false information or material omissions within this declaration? And here, let's go further, because acting knowingly and willfully. Reckless disregard of whether the statement is true or a conscious effort of avoid learning the truth can be construed as acting knowingly. So did they knowingly misrepresent issues with the court? And this again would go to the issues of Rule 65 and notice to the adverse party and violating due process. And are there issues that these would be issues of probable cause of potential federal crimes? So right here, false declarations before the court, 18 U.S. Code 1632, perjury. So if they testify during these cases and misrepresent, is it 18 U.S. Code 1621? Then there's issues of due process and willfully depriving a right. So does an individual have a right to notice in cases? So are there deprivation of rights under the law in violation of Fifth Amendment? Is there Fourth Amendment unreasonable search and seizures? Is there deprivations under the color of law? Is there a federal right or privilege to use raw milk? Is the government preventing you from doing that with this zero tolerance policy? Is there conspiracy to deprive rights? Is two or more individuals depriving you from using raw milk in this facility? Is there non-joiner of parties? Is there Rule 11, misrepresentations to the court? So how did the Justice Department, how did they do an inquiry of facts and submit this information before the court? So are they basically furthering offenses against the United States? Is there issues of lack of subject matter jurisdiction? Issues of the Administrative Procedures Act? How is there notice in a comment period? Where in the hell did this zero tolerance policy come in if federal law allows you to use raw milk and it's within 13% of the damn commercial milk supply? Would it be cruel and unusual punishment inflicted if you were forcing someone to have basically, 10 to the 1,000th power probability of complying with this order? And then all those individuals, all those in active and concert and participation, are they subject to civil and criminal contempt? So again, that's with declarations from the named individuals, their expert witness, the issues. So here, there's countless legal issues, I believe, within the union case. I believe there was issues of knowingly and willfully. Are the requisites for a valid judgment? So first, persons who interest in the adjudication must be given adequate notice of the proceeding and an opportunity to be heard. Did that happen? Also, the court must have authority to adjudicate the type of controversy presented to it. This authority is generally referred to as subject matter jurisdiction. So, if they gave false information of the manner or method of production to claim adulteration, and if there's issues that they could not claim adulteration, then you couldn't have injunctive relief, and the court lacks subject matter jurisdiction over this matter. So I believe there's just countless legal issues that the court, and then you'll see the conclusion of the law, it asserts the court had jurisdiction over the subject matter and the parties. I believe that that's not true. I believe it conflicts. And I believe here, Codes of Candor of U.S. judges, a judge should perform the duties of the office fairly, impartially, and diligently. A judge should accord every person who has a legal interest in the proceeding and the person's lawyer the full right to be heard according to law. So are there legal issues that there's deprivation of rights under the color of law and violation of due process within this case? Again, lack of subject matter jurisdiction and failure to join an indispensable party pursuant to Rule 19 with lack of subject matter jurisdiction can be raised at any time. That the right to sue and defend in courts is the alternative to force. In an organized society, it is the right conservative of all other rights and lies at the foundation of orderly government. It is one of the highest and most essential privileges of citizenship. So here, are they depriving the right to defend in court by misrepresenting the named individuals? And was it willful? And then the issue of the right to sue. You'll see here filed in another case of 4/1801. Here, Antonio C. Gongali, the third petitioner, memorandum of opinion. Here, Gongali filed a pro se petition for redress pursuant to U.S. Constitution First Amendment petition for redress of grievances petitioner is adjourned from filing any new lawsuits or other documents with this court. So there was no right to be heard during this. I believe it violates the First Amendment to petition for redress of grievances. I don't believe he enumerated or discussed all relevant factors when he determined these things. So I believe that there's just countless legal issues within this case and the union case now. And there's case law within this case here. And you'll notice under the First Amendment Constitution, the First Amendment, and you'll see here the petition for redress of grievances. Irreparable harm, showing irreparable. For an injury to be irreparable, a plaintiff need only show that it cannot be undone through monetary remedies. Deprivation of a procedural right to protected parties' concrete interest is irreparable harm. So when the Food and Drug Administration created the zero tolerance policy for Listeria, was the Administrative Procedures Act followed? Was it published in the Federal Registry? Were there countless legal issues? And so were persons' concrete interests, was the government inflicting irreparable harm in the union case? Let's go further. Additionally, violation of First Amendment constitutional right for even a short period of time is always irreparable harm. So when the Northern District Court of Ohio permanently adjourned me from filing any new lawsuits or other documents with the court, is there always irreparable harm? So did the court create numerous legal issues, not only in the union case, but then barring me access to the court? And is that order even possible? So if the order is not possible and they brought injunctions saying the public health and safety, and here it's being violated, and then you're depriving someone to bring these issues before the court, is there just countless issues of that you're creating enormous legal issues and concealing possible issues of the misconduct that the government engaged in? So I believe there are just so many legal issues that are just compiling. Here, the plaintiff argues the First Amendment violations are continuing and that there is substantial risk of future harm is likely to occur. So is that true in my cases as well? Here, Marbury versus Madison, if he has a right and that right has been violated, does the law of the country afford him a remedy? Is there a remedy? Supp versus Dulles regarding Eighth Amendment. There may be involved no physical mistreatment, no primitive torture. There is instead a total destruction of an individual status in organized society. It is a form of punishment more primitive than torture, for it destroys the individual's political existence that was centuries in the making. Does barring someone's access to the court, does it deprive the individual of his status in organized society? Let's go further. Here it says, so in Supp versus Dulles, he would enjoy limited rights of an illegal alien. So he enjoyed limited rights. So in my particular case, did they bar me access to the courts, which is is how all other rights are protected? So am I in worse position than Supp was? And they've determined that to be more primitive than torture. So am I in worse position than Supp? Confirming the right of meaningful access to the courts, deemed sacred and inalienable, but it has also made most important of all because on it all other rights, even the rights to life, liberty, and the pursuit of happiness, were made to depend. In a word, it became the cornerstone of the republic. So did the Northern District Court, did they conduct a federal trial with wrong individuals, and is the order impossible with countless civil rights violations and possible countless federal crimes? Then did the Northern District Court, without hearing, without a right to be heard, permanently bar a United States citizen access to that court? I think these acts were absolutely egregious, and I believe that there was willful conduct. There are no other rights if you cannot defend them. So where I think it becomes legally questioned is if the courts, if the right to sue and defend in court is the alternative of force, and they deprive you of the right to sue and defend, did the Northern District Court create the alternative? So are there countless legal issues here? And now recently, we have the court case of where they overturned Chevron. So was the administrative agency, are there legal issues did Chevron, does it raise legal issues within union when they overturned Chevron? There's just countless issues. If you know any attorney out there that'd be interested in taking up these matters, I've been trying to find counsel to look into these. And was this order impossible? Could it have been complied with? I want to thank you for your time.